Meet Sylvia Ho, a lawyer who's got the legal info that business people need to know.
Hello, Matt. We're continuing our conversation with attorney Matt Patterson about patents. Thanks for coming,
Hi,
Matt.
Sylvia. Hi, Sylvia. Thanks for having me again.
Now, continuing on our last conversation, which were the basics of patents, I want to dig a little deeper. It's going to be information that I think is important to entrepreneurs and of companies that want to have a competitive advantage. And we've used a hearing aid as an example in our last session, so I'm going to use it again. Let's say that your hearing aid is an innovation. It's going to be it's going to be a category killer. Everybody else who has the old hearing aid won't need it anymore. And so my question is, it's created by a team of inventors. Oftentimes, it's not just one inventor, one small inventor that's in a garage doing something, but it's a team of people in a company that's been tinkering around with it or studying it and developing it over a number of years, months, and years. And so in my hypothetical, how is this handled from a patent perspective? And who is the client of the patent attorney?
Right. So in this situation where there's a team of inventors working for a company, right? They typically have an intellectual property agreement with that company where they are obligated to assign any intellectual property that they develop to the company. So the company is the client. The company is the client of mine, of the patent attorney. And so the company comes to me and we talk about the invention disclosure, right? So I like to think of it kind of as like a like bowling, where you set up the pins, right? Of the old, here are all the problems of the old technology, right? These are the pins. And then we're going to roll the ball down and knock down all those pins, and the ball is going to win because that's the new technology, right? So the invention disclosure talks about the old, the old technology, the problems that need to be solved with that old technology, and how the new technology solves all those problems. And so that starts me on the way to being able to look at the patent. And we talked about in the last part of the series was the timing, and the timing is very important to talk with a patent attorney and start to get the ball rolling on the patent as early as possible, because the earliest filing date secures the invention.
We talked about the employees not being owners of the patent, but the company. Oftentimes, so that would involve employment agreements, something that I do in my practice, and confidentiality and non-competition agreements and so forth. Sometimes the employee's name is present on the patent, so you might have a few. How is that handled with regard to making sure that the company secures this patent and the employee doesn't come back later and say, hey, I worked on that. I have a right to a percentage of the profits now.
Right. So the employment agreement that we talked about, an employment agreement typically has an intellectual property section, or you could have a separate intellectual property agreement for people who are hired to invent, and they're obligated to assign the patent to the company. And so the inventor's name always shows up on the patent, okay? But then there's, it's just like when you transfer property, you file transfer of title, right, from the previous owner to the current owner. And so the same thing happens with an assignment at the Patent Trademark Office. So all the inventors assign their rights in the patent to the company, and then the patent attorney files that assignment with the Patent Trademark Office, and thus records the ownership interest in that patent.
Very good. And so, so here we have touched on, you know, for the viewer, the combination of a business lawyer with a technical lawyer, which is a patent lawyer, which is both play a part in the transfer of that technology and the protection of that asset for the manufacturer or of the product. So thank you
Right.
very much. Okay, and well, next we let's talk about something that doesn't go well. What are some common pitfalls or mistakes that companies and individuals who are um, uh, in charge of companies make, and even general lawyers, I mean, business lawyers make mistakes when it comes to intellectual property, because it's such a technical sub area, yet it touches the law in many, many ways. What are some common pitfalls and mistakes that happen that cause an inability to patent, or an inability to maintain the right to assert that patent when it's needed?
Sure, I mean, the one we just talked about, you failed to get an agreement with the inventor, and now the inventor owns the patent because he didn't assign it to the company. That's very fundamental, but it happens more than you think. And then the second thing is, you know, inventors are typically engineers, and engineers like to brag about what they do. And so they write a paper for whatever society they belong to, right? Petroleum Society or Mechanical Engineering Society, whatever it is, and they want to present their paper at a society meeting. And so if they do that, right, that's a public disclosure, right? And you have 1 year after a public disclosure to be able to file in the United States on your patent. And in other countries, if you want to file outside the US, most other countries, you are completely barred from filing a patent if you publicly disclose. And sometimes it can be just even the abstract that you submit for the paper approval that could bar you from filing a patent, right? Would stop you dead in your tracks. And then the other thing that happened, like I said, that happens more than you think. So, you know, one way around that is that you file a patent on whatever it is you're going to disclose to the society. It's, you know, it's a straightforward thing. You know, patent attorneys do that every day. I do that every day. Another very common thing where you could lose your rights is to sell the device before you patent it, right? So you always have to file before you sell to be able to make sure you secure your rights. You know, I've had people come to me, I've been selling this widget for 3 years, it's finally taken off, now I want to patent it. Too late.
So you raise a lot of different points that I, as a business lawyer, think about all the time from the perspective of employment law and HR law, right? Because confidentiality and non-disclosure is a very, very important part of the employment relationship when you are doing something sensitive and you're developing products for the market that could just be blown if you don't manage your workforce and your engineers and developers closely.
Right.
Second of all, I think you talked about how, as a business lawyer looking at it, how some companies want to wait and see. We don't want to spend the money until the product's taken off, but by that point, it's too late. You put it into the stream of commerce, and so that comes to an issue of cash flow, and in terms of thinking about priorities and what is important, and in doing so, it's better to prepare for that ahead of time than to wait and see and run your company on a wait and see basis. Because if you think that you have something that might be a category killer or is innovative or gives you a competitive advantage, you've got to decide where is your money well spent, and how much are you going to invest in it, right? And I think that as lawyers, the public think, well, if I even sneeze, a lawyer is going to charge me money, right? But we don't do that. And I think that's a grave misconception, especially in business law and in what you do, Matt, that people are not understanding about, because there are all sorts of arrangements. So could you talk about some of the ways that patent attorneys charge and how they work hand in hand with the companies that they represent?
Sure, Sylvia. So, I mean, one important point that you made was that, these are expenses that, a company, especially a startup or a smaller company, needs to budget for. They really need to have an IP. If they're IP centric or developing IP, they need to have an IP budget, right? It's a real cost. And so, so the budget is the first thing, right? And then so when you're looking at what going forward, what to protect, what to capture, right? It's typical that you have a group that, like a committee or a group that looks over your intellectual property and can identify it and can come to the patent attorney and discuss that, right? So what are the different ways that we do this? So I can give advice and give advice at an hourly basis, right? I do that. I can also, in filing patents, you can have fixed prices with patents. So I know you're developing a product. You're gonna you may have 10 devices, and I can give you a per patent fixed price, right? So that's another way that I can charge. And we did talk about the different types of patents, and different types of patents cost, different amounts. So there's also, factors that can come in, like licensing, right? So say in this hearing aid example that we've been using, it's really so there's a sensitive microphone in there, right, that picks up all ranges of frequencies.
Right. That's
okay?
how hypothetical.
Well, that would come in handy, say, in intrusion detection, or say in leak detection, or all kinds of other areas that the hearing aid company doesn't care about, right? They care about hearing aids. So, but they now have developed this technology that they could license outside of their own, what we call the field of use, right? And it wouldn't impact their revenue stream whatsoever, right? But it would be their revenue stream for hearing aids, but it would certainly create a revenue stream from the licensing standpoint, right, for these other sensor technologies or wherever they could use it. So that is, it's not a different way of charging, but it's a way of thinking about the costs and maybe the cost recovery for the patenting process.
So really, I think that not only for patent law, but for any business, thinking about revenue streams and being creative about what your asset is, because really after a while, after you think about it, after you file that patent, you do have an asset, and how it's intangible because it's intellectual property. You can't see it, but you can sell it in all sorts of ways. So why is it that you would wait and see? Why would you put that in jeopardy if it's something that is important to your overall success as a company?
Right. I mean,
That's a
so
big mistake.
when we talked about this as well, that a patent is a legal monopoly, right? You can't, absent a patent, you can't stop somebody from making what's in the public, right? Just because it's yours. Once you sell something without a patent, anybody could copy it, right? And so this intangible asset has a lot of value in you being able to stop others from competing against you because you have this patent, right? And it is, it's a, you know, it's an intangible asset, and you know, and people even can borrow money against patents, right? They put them up as collateral, right? And so these are really, you know, assets that hit the books, right? And not only contribute to the bottom line, but hit the books as an asset.
Yes, well, and if you borrow any money, do any financing at all, that patent's going to be listed on your financing statement for sure. So,
Right.
any other mistakes that I might have missed, or you might have missed?
Well, I think that you know, the only other issue is, you know, the employment agreement, right? So it's very important to have employment agreements, especially with clever, creative people, because they are clever and creative, and you don't want them, you know, leaving with that asset, right? You want to make sure that, you know, you secure the rights through an employment agreement that's enforceable, and that's why people come to you. And you know, otherwise, you know, somebody could say, look, you didn't hire me to invent, you know, now you know, and I invented this thing, and I'm taking my hearing aid and going home, right? And the company is left now to have to litigate with this guy, right, to sue to get.
Or I went to your competitor, they hired me,
Right.
and your legal,
Right.
and your hearing aid, right?
Right.
They offered me more money, and now the other company is going to sue you because you're infringing on my patent, right? There you
Right.
go, right?
Right.
So,
Right. So well, I
and
think
that's
that's
really
really
more
going.
expensive. That's really, excuse me, I'm
Oh.
sorry. That's really
No.
more expensive than what we were talking about before, because the cost of litigation is huge. And it could take
compared to a patent.
years, and you could have an injunction and never be able to use your hearing aid.
Right.
And that would
Right.
create the company in, if that's your only product, right?
Right. And if the inventor left before the filing of a patent, then the company loses twice, right? Because they lose the ability to patent, and now they have to sue the former employee, you know, for theft of the technology.
Right, right. And he's in his garage
Right.
making.
Or at the hearing aid competitor. Right?
Or the hearing aid competitor, and that often happens. In fact,
Right.
the majority of scenarios in lawsuits that are so expensive and so acrimonious has to do with either the inventor going away or the key employees leaving with the intellectual property, and
Right.
fights in the patent and trademark office and fights in federal court as well. So
Right.
that's a very classic rubric there. So it's
Sure.
very important to invest that money so you never end up on the other side, because who wants to take your cash flow and your assets, right, and liquidate it just for the survival of your company? You know, parties are not happy when they're in litigation, and they've spent all that time, investment, sweat into a project that wasn't protected. It's very frustrating. So my third question, what are some, I think maybe this is a shorter question because we've already covered some of these issues with pitfalls and this discussion here, but what are some of the things that business people or an attorney referring an invention should do to be diligent to avoid the frustrating process of expending fees later or possibly losing out? I think we've talked about timing, right? Employees.
Earlier is always better, right? Yeah.
Anything else?
So, I mean, it's always best. What sometimes happens is everybody's busy. Okay, so the engineer is very, very, very busy, and I get a you know, what I call a skinny disclosure, right? So I get 10 bullet points, and I'm supposed to, you know, put together a patent application on that, and then, you know, so say we file a provisional patent application and on a skinny disclosure, and a year later we have to file a non-provisional, right? And the guy is still busy, right? You need to take the time, right? You need to, and it's better to take the time up front and do as good a disclosure as you can so we get the best patent on file at the very beginning, because you're never going to have time later. And then trying to clean up the mess after that, if you haven't made a full disclosure and your patent is not enabled because you didn't give me all the information that's in there, you know, you could end up not getting a patent in the end, or spending a lot more to try and get it through the Patent Trademark Office, what we call prosecution, trying to prosecute the patent through the Patent Trademark Office because the disclosure wasn't there. So that's another thing that, you know, you really want to avoid. It's, you know, so it's not only the money, it's the time, right? So if you spend years fighting with the Patent Trademark Office, those are years that before you get a patent, if you get it at all.
Yeah, right. And it's interesting because there's innovation while you're innovating, someone else is innovating.
Right.
And so your time to market is very important. And if you get tied up in litigation or constantly trying to deal with the Patent and Trademark Office, you've lost years of competitive advantage there.
Right.
Yeah,
Right.
and we've
Right.
seen that in the marketplace, right? Something comes
Absolutely.
up, and then there's 6 of them, and then the consumer is like, well, which one do I pick? Right.
Right.
So
Right.
if you aren't able to patent, suppose all is lost and you're not able to patent, is all lost?
So go back to our hearing aid example, right? So in the hearing aid, say the company didn't patent it for whatever reason, all the myriad of reasons we've discussed. It's not all lost, because somebody could take that hearing aid and reverse engineer it, okay, and put it back, you know, try to copy it, right? But in that hearing aid, there's certainly going to be things that you can't discern from looking at it. There's firmware on a chip, right? There's you know, typically devices you can, right? But say there's special glues or things that you can't reverse engineer that are on there, right? You can't tell. I wouldn't be able to tell, but the engineers at the hearing aid company know all that goes into that.
Right.
And so what you would do is you would protect those as a trade secret. You would keep those secret within the 4 walls of the hearing aid company that developed that. And, you know, you would have an advantage over somebody else who may take, you know, multiple tries and years to try to reverse engineer that. And that gives you the hearing aid company that developed it the competitive advantage to get out there in the marketplace first, right? So the trade secret would be the way to protect that stuff.
So, but it's not 100%. You don't get a monopoly, right?
No.
You have to be you have to call on all of your marketing prowess as a company to get yourself an advantage, and then get your brand out there. And we're going to do we're going to interview a trademark lawyer, a national trademark lawyer, on the branding issue, to establish enough in the thought of the consumer that your brand is better because you've made it, because you don't have that patent. So it's still a painful ordeal if you don't do it right the first time.
Right. And you only get one crack at a patent, right? So if something doesn't go right anywhere along the path, right, and you lose your ability to patent some of the things we've discussed, you can't go back and recover from that, right?
Thank you very much, Matt. So this is we're going to continue this series. The next series, I hope we have a little fun, and you bring some of the things that are patentable, and
Right.
we can take a look at them. And then we're going to talk about protecting patents from foreign competitors and from copying and other things. And then we'll conclude with patents. So I'm looking
Yes.
forward to all your different devices and toys and learning
Yep.
about them.
Yep, I'm looking forward to it.
Thank you, Matt.
Okay, Sylvia. Bye.
Bye.
Do 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 do.